The court is ready to hear argument in 1996, Farmers Group against Jeter from Jefferson County and the 13th Court of Appeals District.
May it please the court, Ms. McKillop will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Thank you and good morning. Today we're here to discuss the proper way to change a policy form statewide through non-renewal. Before I start talking about the statute and the insurance policy, if I may, I'd like to set the scene back in 2001. Back then, there was a huge increase in mold claims that was causing a massive amount of underwriting losses for the Texas insurers, which means that the losses greatly exceeded the premiums. So the Texas Department of Insurance, the TDI, became concerned that because when claims rise, paid claims rise, premiums also rise, that homeowners insurance would become unaffordable in Texas. Now, back then, of course, we didn't have your FICE decision, and so the presumption was that most all of these mold claims were covered by the old HOB form. So what happened was, because of the underwriting losses across the state, not because of individuals, one or two individuals or an individual claim, farmers decided to non-renew the HOB policy and offer an HOA policy to every one of its insureds. The TDI approved this move and, in fact, a year later mandated it. So how do we figure out how the Texas Insurance Code and the insurance policy, Section 6, go together to allow statewide non-renewals, yet at the same time still protect individual insurers in an individual non-renewal instance? So this is the way that it works. Section 5 of the Insurance Code allows non-renewals conditioned only on 30 days notice. It's not conditioned upon the insurer's loss history at all. So then we have Section 6 of the policy, which is reflected in Section 7 of the Insurance Code. There are mirror provisions written a little bit differently, but basically the same thing. And you look at these to decide when the individual insured's policy may be non-renewed, yet the policy form remains available to everyone else in Texas. So it's fairly straightforward. How do you look at Section 6 of the insurance policy and decide whether it applies to statewide non-renewals or applies only to individual losses and claims? So what we've done and what we believe is correct is that—
Do you argue that that provision does apply to this individual claim?
Yes, ma'am, it does. If an individual insured is being non-renewed, then Section 6 does apply. And let me skip ahead to tell you the reason they all work together. When you have an individual non-renewal of a policy, that means that the insured doesn't have a policy anymore. They're not being non-renewed like a statewide non-renewal to change policy forms and being offered a substitute policy.
So what in the insurance code gives the TDI the power to rewrite the contract? I mean, it seems like you would get into constitutional claims about impairing contracts and that sort of thing if they're rewriting contracts that are in force. I mean, I understand your point about that the policy is not referring to statewide losses, that they're referring to individual losses. I understand that part, but if the policy were written as such that it had to be renewed for some reason, could the TDI just come in and say, we don't think so, and cancel that policy even though the policy says otherwise?
So I think how that works is that these policies are one-year policies. And so non-renewal can only happen at the end of the policy.
But so if the TDI, say TDI wanted to cancel the policy in the middle of the term, could they do that?
Good question.
Could they order the insurance company to do that? And would that be okay? Would there be no breach of policy claim for that?
As far as the TDI is concerned, if the TDI mandates the insurance companies do something, we're a regulated industry, and I think we have to do it. But I will say
But
that
could
I
you
have
then
never
be
heard
sued
of,
by the insurer for not complying with the policy?
and again, I think that the issue becomes non-renewal is not like cancellation. Cancellation happens in the middle of a policy or can happen, but non-renewal is only at the end when there is no policy. It has to be renewed for there to be a contractual relationship between the parties. So I think that's how it all works together.
Well,
To
except
avoid the
that the
problem that
policy
you're
says the contractual relationship is going to continue absent these circumstances.
Right, and then the question that we have in this case is, do those particular circumstances apply in a statewide non-renewal?
Right. That seems to
Right.
avoid the question about whether the TDI can change the terms of your contract. If you approach it
Correct.
that way, to say that the contract doesn't cover statewide losses.
Right, the contract is to an individual insured for that individual insured's losses and claims. And that's exactly how it works. So let me get back to, I was talking about the individual's position. So if the individual insured is non-renewed for the individual reasons, that means that they have added protections. So if they happen to live in an area in Texas where there's a lot of windstorm or hail and they get a lot of natural caused losses, they're not going to be non-renewed.
Well,
If
let
they
me,
happen to have-
so are you agreeing that in this particular case that mold is a natural cause?
No, it's not. I don't agree with that. I think that it was pretty evident from what was going on back then and also from what the TDI was saying that mold is a piping leak issue. And I'm old enough to remember this, as were a lot of the problems that happened with the HOB policy back in this time period, including foundation and the extent of water losses. So I think that was the problem then. So just to get back a little bit, so if you're an individual insured and you're non-renewed and you're not going to get another policy, unlike a non-renewal statewide to give insureds other policies, you have these other protections. You have a natural loss protection, you have your elected official protection. You have protection if you've had some claims, but not too many claims. And so that's how Section 5 allows the statewide non-renewal. Section 6 provides protections for the insurers when they're being non-renewed for a particular reason, then they're not going to get another policy. So let me jump now to the Court of Appeals decision. And the Court of Appeals
Before you
largely,
go there, Ms. McKillop, so if mold were a loss from natural causes, you talked about underwriting losses, meaning that the premiums did not cover the amount in claims. Is an underwriting loss a loss from a financial loss or a loss from natural causes?
well, I guess an underwriting loss could be lost for many different reasons. You could have an underwriting loss for natural causes like windstorm and hail. You could have them for non-natural causes, which way policy says it, for theft and fire, not lightning, fire, and things of that nature. I don't know if I answered your question, though.
Well, it just seems the loss to farmers is a loss, and when the revenue from premium doesn't equal the amount they pay out in claims, but not actually farmers claim for a loss itself, but rather it's underwriting loss, which seems different than claims for losses due to natural causes.
Yes, ma'am, that's exactly what I'm trying to say. That it is different. The individual claims are different from the underwriting losses, if that makes sense. And of course, going back, we know that the policy is referring only to individual losses because of the same meaning rule. You look at what, since they're undefined terms, losses and claims have to be used consistently in the policy. And it's pretty obvious that an individual insurance policy is only talking about the individual's loss and the individual claims. And so in Section 6, claims and losses, by that rule, mean individual claims and losses. Then jumping to what the Court of Appeals did here, I want to digress for just a minute and talk about what I think might be a difference between what the Court of Appeals has held and perhaps what the plaintiffs are arguing. It seemed to me, and Mr. Warner will tell me if I'm wrong, that what they were saying is that you could non-renew a policy statewide for any sort of reason, as long as you didn't put the reason in the notice, and that just by putting the reason in the notice, and that is what in fact makes it wrong here. I don't think that's what the Court of Appeals said. I also don't think it's a good rule, because then you're encouraging the TDI and the insurance companies not to be straightforward about the reasons that they're actually non-renewing the policy. And in fact, the Texas Insurance Code requires you to tell an insured why you're non-renewing if they ask. So then jumping, if I could, to the Court of Appeals decision. So the Court of Appeals says that Section 6 applies to statewide non-renewals. But what problems does that cause? Actually, a lot of them. So what that means, if the TDI wants to change a policy, the insurers want to change a policy, what they have to do, if that change is based on natural losses, that wasn't the case here, but if it is based on natural losses, then they can't change the policy form without violating Section 6A if any Texas insured has had a natural loss claim. And I didn't make this point as clear as perhaps I should have in my brief, but think about the Jeter rule as applied to Section 6C. 6C is an exception for all types of losses that are non-natural. So that means for the TDI to allow and the insurance companies to be able to make a statewide non-renewal, if it was based on any kind of loss, where the TDI wanted to add coverage, delete coverage, or do anything they wanted to do, then they couldn't non-renew unless every single Texas insured had 3 losses in the past 3 years. So it's just an unworkable way of going about changing policy forms. And what it does is it keeps the TDI and keeps the insurers, from operating to solve a problem like the mold crisis. And if the court doesn't have any other questions, I'll keep the rest of my time for my rebuttal.
Any other questions? Thank you, Ms. McKillop. We'll hear from the respondents.
May it please the court, Mr. Warner and Mr. Blanks will present argument for respondents. Mr. Warner will open with the first 15 minutes.
May it please the court. I had posed a question in my briefing, and my friend, Ms. McKillop, I don't think answered it in the briefing and didn't answer it this morning. And I think it's a question that explains why all of this business about the farmer's TDI relationship is a red herring. What if the notice had been sent to Ms. Jeter by email 10 days before it was to be renewed? Farmers' argument seems to be that essentially, as long as we've gotten permission from the TDI to do a non-renewal, it doesn't matter whether we do it properly. And that's not correct. I mean, the Texas Department of Banking oversees Wells Fargo, but if Wells Fargo manages to send a notice of acceleration improperly, that's a problem between Wells Fargo and its customer. It was said in their argument that these all work together, the legislature, the TDI, the farmers, an insurer like Farmers and Ms. Jeter, but they don't work together in this kind of a way. And I prepared my very simple demonstrative exhibit, which I hope you all can put on your screens because I wasn't able to make it work with Zoom. They're not working together. They're on a continuum. Ms. Jeter, she's a very sweet lady. She lives in a house that was built in 1923. She's a licensed master social worker. She's dealing with farmers. That's her relationship. She's not watching what's going on at TDI. She's not apprised of the changes in Texas law from the legislature. She's dealing with farmers. She's relying on the communication that she gets and the policy she has with farmers. The farmers has to be cognizant of what's going on with the TDI. as well as being cognizant of its policyholders. But just because it's copacetic with the TDI doesn't mean that it's automatically copacetic with Ms. Farmers, because she shouldn't have to try to see beyond that. And certainly not to the legislature, which meets only for a few weeks every 2 years. The legislature sets out some very broad markers for the TDI to follow so that the TDI needs to go about its business. That question's never been answered, and it can't be answered because, again, fundamentally, this is just about a bad notice. The policy says you have to give proper notice of non-renewal. They didn't. Proper in the eyes of Ms. Jeter, in the eyes of the common meeting to a common insured person. Now, I've asked a rhetorical question, and a rhetorical question was asked of me. I have not answered it till now, but certainly now is the time. What happens next? Because the Court of Appeals said, we want to remand for remedy, if any, and that was a little bit unusual. The remedy, I think, I've become a student, I guess, of 37.001 of the Civil Practice and Remedies Code recently, which I honestly had not even known existed. I don't know if we call it a remedy. I think the outcome, the most direct outcome, is simply that the court will enter a declaratory judgment and it'll become a final judgment. Notice will be given to the class members that, hey, this is what happened. The court made a declaration that when all was said and done, Ms. Jeter was right, Farmers was wrong. That can be the end of it. I'd alert the court to Allstate versus Hallman, 159 Southwest 3rd, 640, from the Texas Supreme Court in 2005. I may have to file a supplemental brief. Hallman was sued. Hallman brought a declaratory judgment action against Allstate for coverage because there was a dispute. Hallman loses at the trial court, wins at the Court of Appeals. On review to the Texas Supreme Court, Hallman is found not negligent in the underlying trial. So indemnity, we don't have to worry. There's nothing to indemnify. There's not going to be anything to indemnify. And for reasons that aren't clear, Allstate had agreed not to recover their defense costs. So the issue of defense is not even an issue. And this court wrote, it's still a live issue. There was a declaration, a declaratory judgment that took place about who was right and who was wrong. And yes, maybe 5 years after the fact, well, in that case, we knew that there was absolutely no further step after final judgment was entered. But the court said, go ahead, enter final judgment, award attorney's fees to the prevailing side if the court finds it was necessary. Here, there is more that could be done. 37.001 is an exception to the general rule of res judicata. Under the Valley Oil case, Valley Oil versus Garland, 499 Southwest 2nd, 333. Any court with jurisdiction can be asked to give further relief. We've got 433,000 class members. I expect that the vast majority of them will receive their notice and not do anything about it. Some may wish to do something about it. What they might do, I can't predict. My posture in this case is like the 8th inning reliever. I didn't start the case. I'm not going to be the closer. The 8th inning reliever wants his 3 outs and wants to hand the ball off. I want my 4 votes, and I want to hand this case off to my managing partner to get this thing to the finish line. But it's the same situation. The court has said there was a declaratory issue between Ms. Jeter and Farmers, and Ms. Jeter was right, and she deserves to get that final judgment that says that she was right. In that regard,
Counsel, if I could focus you on the language of subsection or section 6A of the policy. Do I understand your position to be that, do I understand correctly that you'd say you can, no matter what happens out there in the world, losses from natural causes can never be a basis for a change to this policy? And it doesn't matter whether it's a systemic wide change, that there's no way farmers can get out from under a policy because of systemic or statewide losses that are incompatible with its expectations or whatever. It's just stuck with this for good.
No, there are two ways that farmers can get out of it. One way is what actually happened in 2003. And if the court will see, this was a very precisely tailored class only for the 2002 renewal. 2002, farmers had an option. Farmers could either renew the HOB or attempt to non-renew the HOB. Come 2003, the department said, nobody can offer the HOB anymore. Farmers asked the question in its brief, well, doesn't that mean that they're going to get sued for breach of contract? Well, one would think so, because impossibility is a defense as a matter of law, prevention by government regulation. I can't renew because my government regulator told me I'm not allowed to renew. That's going to be a complete defense. The second way they could do it is to send a proper notice. They didn't have to give a reason. I get my auto policy seems to change every 6 months. I get notice of it. I don't get a reason. They could have said because there are changes in the availability of process. They could have.
So you say if they sent a notice that didn't mention their losses, that would have been proper, that would have effectuated a non-renewal, even if their true reason for the non-renewal is their losses?
That's correct, Your Honor. I mean, this isn't, we don't have pretext issues here. I mean, we've got a customer who's just looking at, there are reasons that we have that are allowed to get non-renewed, and there are reasons that we're not. And that's it. And it's important that the reason be given be a proper reason. I mean, we don't.
And I guess the question that this may come down to is certainly there are reasons that are proper for non-renewal and reasons that aren't. And the question is, what are those reasons? And Farmers says, well, the reason we couldn't non-renew is because of your losses under this policy. And you're saying, no, you can't non-renew because of any losses under any policies. And that's really, I think, the crux of the issue that you might want to address.
Sure. Well, Farmers said, we are not, Ms. Jeter, we're not renewing your policy because of losses. And these are, she knows these aren't losses based on non-natural claims, because if it was, she'd get sort of the 2-claim warning. So she wants coverage. She's just like me with a disability insurance policy. I've got all risk, and this HOB was all risk as compared to OA. I want coverage. When I bought it 2 years ago, nobody knew what COVID-19 was, but if God forbid something happened to me, I would want coverage. And if I get a notice that says my premium might go up next year, I still want to pay it. I still want cover, or at least I have to make the choice. I still want coverage, even if there's something called COVID-21 that shows up later this year. That's what she wants. She wants the coverage, and she gets a notice that says, we are non-renewing you for precisely the reason that we've agreed we're not going to non-renew you for.
But Mr. Warner, I think the question is that the reason that they promised not to renew her? Is claims by other people for losses that may or may not have resulted from natural causes a reason that this policy says they can't refuse to renew her? So what's your best argument that that's what this policy is talking about?
Yes, Your Honor, and the Court of Appeals mentioned it specifically because even Section 6 differentiates between claims for losses, and I like to think of them as the same thing, or claims by you for losses. If you go to Section 6C, they're talking about if you have filed 3 or more claims under the policy, if you have filed 2 claims in a period of less than 3 years. The Court of Appeals was very perceptive, and well, that is to see that, and of course we had argued that as well. That's the distinction. The policy itself distinguishes between claims made by her, or claims for losses made by her, and claims for losses. They're not the same thing.
And what about the qualification that it has to be resulting from natural causes? Farmers says mold claims often are caused by non-natural means. So how do we deal with that issue?
Well, Ms. Jeter gets a notice that says losses, and she knows they're not losses from non-natural causes because otherwise it would have been one of those sort of warning shots. And certainly I will make the comment that this is all extrinsic to the record. We're talking about Ms. Jeter versus Ms. Jeter and farmers. A lot of these mold claims were water pipes freezing, bursting after freezing. There are a lot of ways that you can get mold or any of these things that are based on natural causes. I mean, this was not a spate of arson around the state that was causing this problem. This was not a spate of, civil unrest or something like that. I mean, we've got fundamentally natural causes going on here.
So what happens though when some of them are caused by, say, the plumber connected the lines incorrectly and that's what caused it to leak, and some of them are caused by freezing pipes. Some are natural, in other words, and others are not.
Well, they are. I'm sure that farmers who's insuring 433,000 people can always point to some claim somewhere out there that's not from natural causes. But in terms of the ordinary everyday meaning of the word to the general public, these claims are from natural causes in the general sense. I mean, TDI has not even as much as filed an amicus brief here, because I think they're recognizing that this is just a matter of improper notice by an individual company to its many insureds. If I may, in my 1 minute that's left, there's just one point I'd like to underscore. There is, as difficult as it is to have a waiver, Farmers has waived any attempt to reconsider the fees on this case. Farmers never argued anything to the Court of Appeals other than that essentially, because we farmers deserve to win the declaratory judgment, the plaintiffs don't get any fees, and so they don't get to do anything. The Court of Appeals said no. The Court of Appeals said they didn't even further, they didn't make any further arguments. This court has said in the case of Kachina Pipeline versus Lillis, 471 Southwest 3rd, 445, Texas Supreme Court 2015, that when an appellate court reverses a declaratory judgment, it may reverse an attorney's fee award, but it's not required to do so. And I recognize that the sort of the common practice of the Texas Supreme Court is to reverse and reconsider, but it's not required to do so. So there's no error by the Court of Appeals. And even if there were error by the Court of Appeals, the unbriefed point number 3 that they raised, unbriefed issue, is whether the award of fees and costs to plaintiff under the Declaratory Judgment Act should be vacated because the award presumes that plaintiffs prevailed on their claim for declaratory relief, which if reversed by this court will not be the case. So we urge affirmance. If it's affirmed, the declaratory relief is affirmed. What got lost along the way was part of the remedy of the court basically setting the premium rate. But because of that, we would respectfully request affirmance without even reconsideration of the fee issue, because it has been waived by farmers in this particular case.
Thank you, Mr. Warner. Any further questions? Thank you. Mr. Blanks, we'll hear from you.
I assume I'm alive and seen.
Yes.
Okay, pardon me. Well, I represent intervenors in the Jeter case, and the intervenors went to Austin to intervene in a Attorney General sponsored class action against farmers. And the intervenors were there to protect and preserve the rights that the Beaumont court would be deciding in the Jeter case. And that effort extended over a decade or more. Ultimately, and only because of the intervenors' efforts in Austin, the district judge decided to carve out the Jeter claims from the class action over which he was presiding. Judge Jenkins refused to approve the settlement that farmers and the state had agreed until the Jeter claims were carved out of it. So all of the intervenors' efforts in Austin were solely to preserve the Jeter right to a declaratory judgment and not to promote the class action pending in Austin. That was well handled by the Attorney General's office and farmers. You know, as originally pled and as originally set out in the settlement agreements between farmers and the state, all of the Jeter claims would have been released in the Austin class action. And had that happened, of course, we wouldn't be here today arguing about the Jeter case because, well, it would have been concluded in Austin rather than in Beaumont. Well, fortunately, the carve out occurred and the claims were left to be decided by the court in Beaumont, which is what Judge Jenkins actually said on the record. Let them take care of it. You guys think you're going to win anyway, so go on. Thereafter, then, the Hooks and Ms. Nolan intervened in the class action in Beaumont. And that intervention was stricken. The law firm who represented the intervenors also intervened, and its claim was actually severed. And then months later, unsevered and stricken. So the class members were denied their right to basically appear and, in effect, intervene in the class action of which they were members. And the attorney who had preserved the Jeter case from a total release by the Attorney General in the Austin class action was given no opportunity to seek compensation for fees earned in protecting the Jeter class action in the Austin site. We think that the class members had the right to intervene as class members under Rule 42. They also were told in the notice that the district court served on the class that they could appear with counsel, and they were not given, well, let's say they were stricken and did not have the opportunity to do that. And of course, the law firm also intervened seeking an award of fees that were equitable and just and reasonable and necessary under the Declaratory Judgment Act. And indeed, the Jeter class action suit was a declaratory judgment action. And the law firm was given no opportunity even to make its case that it was entitled to anything that was done to support the Jeter class action. So here we are today. I think the Court of Appeals looked at these issues carefully and made the sensible observation about Farmer's argument that res judicata applied by observing that, the Austin court was concerned and could only award fees for work done to promote that case, not the case in Beaumont. And when it carved out the Jeter class, the Jeter claims, even though it didn't specifically speak to attorney's fees, then it basically rid itself of any worry about what would happen in Beaumont, and left that to Judge Floyd to handle there.
Mr. Blanks, your time has expired.
I'm sorry, sir?
Your time has expired.
Well, thank you.
Any questions? Thank you, Mr. Blanks. Ms. McKillop, I believe you have 8 minutes for rebuttal.
Thank you, Your Honor. What I'd like to do is go over a couple of points that were raised by Mr. Werner. The first one I think we heard is that it is the plaintiff's position that if the notice does not give a reason, it doesn't matter what the reason was. And as I said earlier, I think that's not the law in Texas. And in fact, the Texas Insurance Code in Section 9 of the same group of statutes, a group of the insurance code, specifically requires an insured, if asked, to tell the insured why they're being non-renewed. So I think that's an unworkable way of looking at this particular issue. In response to a question about what if some mold claims are naturally caused or not naturally caused, I don't think any of them are naturally caused, but assuming that they are, assuming that one insured or 10 insurers in Texas has a naturally occurring mold claim, that means that you cannot ever change this policy. Because if you apply Section 6 to a statewide non-renewal and one insured has a naturally caused loss, then you can't change the insurance policy. Then moving to how do you actually non-renew a policy statewide, which I think was a question that was posed. It sounded to me as if this would be a perpetual policy because then you could never non-renew it. One thing that Mr. Werner said was that it would have been okay, and I'm paraphrasing him, it would have been okay if farmers had waited to non-renew the beginning of 2003 because the Texas Insurance Code issued, the TDI issued a ruling in November 28 of 2001. It said, okay, as of January 1, you can non-renew and give a HOA policy. As of December 31, 2002, you cannot non-renew. So that was the timing difference. But that then raises a subject matter jurisdiction question because this is a regulated industry. Because, excuse me, I lost myself here. The TDI in 2002 gave the insurers the choice. You can keep with the HOB policy or you can offer some of these HOA policies. So since it's a regulated industry, that means that the regulator has said, you can choose insurer between this policy or that policy. And the trial court doesn't have the subject matter jurisdiction to intervene in that regulated relationship and say, no, sorry, the TDI said it's okay for you to issue this policy, the HOA policy, but you can only issue an HOB policy.
Are you arguing that the TDI has exclusive jurisdiction, Ms. McKillop, over claims against insurers on policies?
No, absolutely not. No, that's what I'm saying over the type of policy that can be issued. In other words, in 2002, the TDI allowed farmers to issue either an HOB policy or an HOA policy. So that's where this.
Okay, sure. I understand that they can only issue the policies that TDI allows them to issue. I think nobody would have any quarrel with that. But I think the question is if they breach a contractual promise to their insureds by not issuing that policy, are they liable in damages for that or some remedy?
Yes, if there was a breach, we're saying here there is no breach because we had the right to non-renew. But if there's a breach, obviously, then we would have to pay a claim. But in this instance, there isn't one. I'd like to make a couple other points. One is that Mr. Warner was talking about the language in section 6C, and all of these sections mirror section 7 of the Texas Insurance Code and are written slightly different. But the one thing that you cannot get around is that the only way to figure out what section 6 does is to figure out whether in section 6 claims and losses mean individual claims or statewide claims. And I don't think you can get around the same meaning rule that every insured insurance policy is particular to them, and they can only make claims for their own losses. And that's what drives the conclusion that losses and claims in section 6 are individual losses and claims.
Your opposing counsel says other places in the policy, it talks about claims by you for losses. And so therefore we should read this provision to be broader than that, to not just apply to claims by Ms. Jeter. What's your response on that?
Well, my response is basically the same. Just because in some parts of the policy it has you or your in front of loss or claims, that doesn't mean the rest of the time that losses and claims are mentioned in the policy, it somehow becomes statewide losses and claims or losses by other people for which you can make a claim on. It is an individual policy, and whether it says you or your losses or claims or just losses and claims, it's only for that particular insurer. Unless the court has other questions, I just ask that the court reverse the Court of Appeals decision.
Any other questions? Thank you, Ms. McKillop. The case is submitted and the clerk will adjourn the court.
Oh, yay, oh, yay, oh, yay. The Honorable, the Supreme Court of Texas now stands adjourned.